Hello, so my name is Erwin, and today I will be talking about medical negligence in India. Man is the only animal who believes in keeping order in his world. So this was one of the reasons that invented the concept of law. So law helped every man who suffered from an injury due to the acts committed by others to seek remedy by means of compensation or punishment to the person committing that act. So let's go further and see what is professional negligence. Professional negligence, more specifically, medical negligence is, as the term suggests, relates to the medical profession and is the result of some irregular conduct on the part of any member or medical practitioner that is related to this profession. So, negligence. What is negligence? Negligence is the breach of legal duty to care. Legal duty of a person means the duty the law gives to every person to respect each other's legal rights. So then only there will be a balance in the society, a harmony, a synchrony in the society. Therefore, the legal right of a person can be defined as the provisions provided by law to respect and protect each other's interests of its as citizens. Uh, so we must remember always when there is a breach of legal right, there is a legal remedy for it. So this is a principle that is derived from a Latin maxim called "Ibi jus ibi remedium." So medical negligence can be seen in various fields, like when reasonable care is not taken during operations, during the diagnosis, during delivery of the child, with issues regarding anesthesia and what do you say, prescription of medications, and problem with the hospital machineries like X-ray machines, CT scans, and all. So these all can be considered as medical negligence. So moving further, and we will see what are the components or what all constitutes to make medical negligence. So the components of medical negligence is existence of legal duty, breach of legal duty, and damage caused by the breach. So, in order to understand the correct meaning of medical negligence, it is essential that we carefully analyze these components. So, we will go further and see what is the first component. The first component is existence of legal duty. So, whenever a person approaches another person trusting him to possess certain skill or special knowledge on a given problem, the second party is under an implied legal duty to exercise his diligence as is expected to act, at least in such a manner as is expected in the ordinary course from his contemporaries. So, it is not that the legal duty can only be contractual and not otherwise. So, failure on the part of such a uh, person to do something which is incumbent, so that which would be just and reasonable tantamount to negligence. So every time a patient visits a doctor for his ailments, he does not enter into any written contract, but there's a implied contract. So and any lack of proper care can make the uh, erring doctor liable for breach of professional duty. So not always. the legal duty will be written. This implies when a person or like a person trusts someone or see trust that someone possesses some kind of skill, so they should exercise their duty willfully and lawfully. So then the second component of medical negligence is breach of legal duty. So there is certainly a breach of legal duty if the person exercising the skill does something which an ordinary man would not have done or fails to do that which an ordinary prudent man would have done in a similar situation. So the standards are not supposed to be of very high degree or otherwise, but just the relative kind that is expected from man in the ordinary course of treatment. So it is not like that. The degree of comparison is very high. So if a doctor fails to do something, so they will combine with other doctor in the same profession and see whether he would do the same thing or not. So then, if he fails to do certain thing, a certain duty, then there is a breach of legal duty. So then the third component is damages caused by the breach. So the injury occasioned by such negligence is liable to compensated in terms of money, and the courts apply the well-settled principles for determination of the exact liquidated amount. So we must remember that no hard and fast rule can be laid down for universal application. So while awarding compensation, the consumer forum has to take into account all relevant factors and assess compensation on the basis of accepted legal principles on moderation. So it is for the consumer forum to decide whether the compensation awarded is reasonable, fair, and proper according to the facts and circumstances of the case. So, moving on further, the liability. Now we will discuss the liability of the person committing a medical negligence. So, the liability of the person committing the wrong can be of two types depending on the harm caused by him to the injured person. So, they are civil liability. So, civil liability, as mentioned before, the person who possesses special knowledge and skill in a field and uses the knowledge to treat the other person, so then he owes a duty of care to the other person. So, if a wrong is committed by him in this period, then he is liable to pay damages in the form of compensation. So, in some situations, senior doctors or even hospital authorities and management are vicariously liable for the acts committed by junior doctors. So, now let's see for criminal liability. For criminal liability, there may be an occasion when the patient has died. So, after the treatment and criminal cases filed under 304A of IPC, which is causing death by rash and negligence act. So the commencement or pendency of criminal trial would not act as bar to parallel civil proceedings for recovering of money or a consumer complaint, nor can the same be stayed. So it can go hand in hand. So there are large numbers of cases where criminal law and civil laws can run side by side. So the two remedy are not mutually exclusive, but clearly coextensive and essentially differ in their context and consequence. So the object of the criminal law is to punish an offender who committed the negligence, but in civil law, the object is not to punish but get the other person or the person whose legal right is breached, or the person who is the victim of such medical negligence. So civil liability ensures that he get the proper compensation for that particular act. So this is all about medical negligence. So leave your comments. Leave your comments, guys.